So, thank you very much for having me here. It's a great honor. So I will talk about the proposed EU IP exception for generics and biosimilar exports. A cure worse than the disease, a provocative question. I think it will be a cure, but how far it treats the disease will depend on how it is executed and how it develops. And I'm sure that this proposed regulation, which will become a reality, will generate a lot of very exciting data where we will need people like Ariel Stern who know how to analyze that data and have the economic knowledge to assess what this will do to pricing. So I think this will be a very exciting field of research for data specialists. But before I continue, I think I will first start to talk a little bit what this fuss is all about. And like in the US, the EU patent laws, they prevent production of generics or biosimilars during patent term, even if these are exclusively produced for export to countries with no or expired protection. And so far, this also extends to so-called supplementary protection certificates, which kind of are similar to the US patent term extension, which allow a patent extension to up to 5 years. And they do that in order to compensate for very lengthy R&D processes and regulatory approval procedures. So the maximum extension you can get is 5 years. And these are intended to protect brand name research investments, but they also encourage generic and biosimilar producers in the industry to systematically expand their production capacity in potential export markets. And this can, of course, be problematic for access, safety, and innovation in the European market. This is why these changes were introduced in Europe, and they are based on 2 studies. One by the Max Planck Institute for Innovation and Competition that looked at the legal framework of pharmaceutical innovation, including supplementary protection certificate, and a study that was won, a tender that was won by Copenhagen Economics and conducted by Copenhagen Economics that studied the economic impact of supplementary protection certificates, pharmaceutical incentives and rewards in Europe. So I have to disclose that I was part of this Copenhagen Economics study. So my role was basically to teach the economists about the legal framework and the legal implications of biologic and generic drug development. And we had like 1.5 years for that study. So it was a tough task to, because we basically were supposed to look into everything. But the economists, they wrote this report. And in the Max Planck report, they proposed an SPC manufacturing waiver, which then, when the reports were published, the European Commission, the EC is not for European Community, because it's not the European Union, it stands for European Commission. They published a proposal for regulation that would introduce such an supplementary protection certificate waiver, an SPC waiver. And I will talk more about what that is. This proposed SPC waiver, in simple words, would allow European companies to manufacture, store and transport generic or biosimilar products during the SPC term. But only if these activities are done exclusively in the service of exporting the generic or biosimilar product to non-EU markets where protection has expired or never existed. And the idea behind this, the expectations are that this would create $1 billion dollars annually in additional exports and an estimated 25,000 new jobs in the European generics business and biosimilars business. The idea is also that this would align with EU initiatives to defend Europe's trade secrets. Of course, if you keep the biosimilar producers in Europe, it would be easier to protect these trade secrets, as we know, are particularly important in the biosimilar sector. The idea is also that it would promote pharmaceutical innovation. We have heard from our speakers today that the production of biosimilars might also include actually a lot of innovative processes that might lead to biobetters, for example, and even processes that could be patented by biosimilar producers again. And of course, another potential good effect would be that we could combat counterfeit medicines by keeping the production of these generics and biosimilars within the European Union boundaries. And thereby we would support the competitiveness, especially of our small, medium-sized entities, the SMEs. So the idea is that this waiver would lead to more competition, ease pressure on public budgets, improve patient access to wider choice of medicines, have a more diverse generics and biosimilars market, and support thereby the EU's commitment to open markets, free and fair trade. And of course, this has some ramifications, and we need some safeguards if we introduce such a new rule. And that's why the original proposal that was proposed in May 2018 was accompanied by a series of safeguards to prevent products from re-entering or being diverted to European Union countries. Of course, the European Union is afraid for parallel trade issues and the undermination of the European IP system. So that is why, under the proposal, manufacturers would have to notify authorities at least 28 days before beginning the manufacture of the location, the product name, and the intended destination. And these details will be made public. Medicines produced under the waiver must be clearly labeled as exclusively intended for export. And under the Commission proposal, manufacturers must ensure that members of the supply chain are aware of the waiver's requirements. And, oh, wait a minute, sorry. Actually, what happened is that the studies that were conducted by the Max Planck Institute and Copenhagen Economics, they recommended additional safeguards and clarifications, such as more details on how the SPC holder would have to directly inform the manufacturer, and clarifications of which party would bear the burden of proof in case of litigation. But these more detailed proposals from the studies, they were not included in the original waiver proposal by the Commission. And that was what was of course criticized. And we criticized that as well in a Nature Biotech paper we submitted that in July, but it was first published in January, early January this year, with Aaron Kesselheim and Jonathan Darrow. And there we said there were too few details regarding the monitoring and enforcement of these rules. And how should patent holders know if producers fail to notify the authorities? Because so far, in the original proposal, the Commission only talked about that authorities should be notified. And also, it was not really clear how the rules would, in effect, in the actual real life, apply. What would happen to pending applications, granted SPCs, and SPCs in force at the date of its implementation. Also, the original proposal wasn't really clear on what to do with stockpiling. Stockpiling is the production of biosimilars or generics before patent expiry that you would then kind of stock and then produce sufficient amount so that you could directly, upon patent expiry and SPC expiry, enter the market. The rules were not really clear on that. And it was also not really clear how this would comply with the TRIPS agreement. So, of course, the reaction by Big Pharma, first I talk about the generic industry. They were clear that they would think that this would be a positive step forward for small, medium-sized companies, patients, and biosimilar innovations. But surprisingly, even the generic industry, the biosimilars industry in Europe, was also concerned that the required disclosure rules of intended destinations places the commercially confidential information at risk as they seek to be the first to launch in new markets. There was also fear that the waiver would not only apply to SPCs, granted after the law's effective date. So the generic industry and biosimilar industry, they expressed some concerns that any practical benefits would not accrue before approximately 15 years. And that is why they were arguing for a retroactive implementation of the law. The big pharma brand name industry had, of course, a different reaction, a different view. And they clearly said that this new waiver proposal would reduce IP rights and thereby jeopardize patient access to innovative treatments. They also proposed, amendments to the waiver proposals, such as that there should be no stockpiling waiver of generic biosimilars medicines while the innovative medicine is still under SPC protection. They ask for more clearly and timely and effective and transparent notification system details. They also highlighted that the labeling measures must be extremely detailed to prevent the products manufactured outside the EU to re-enter the European Union, and they were strictly opposed against any kind of idea to have a retroactive effect of this SPC waiver for obvious reasons. So what then happened is that the EU Commission was, just after the first proposal by the Commission was published, it was scrutinized by the European Parliament's, the EP's Committee on Legal Affairs, URI. By October 2018, a draft report was issued. There were more than 100 comments and calls for changes to the proposal by the Commission. And the Committee of the Parliament opened interinstitutional negotiations with the Council and the Commission. The Council then agreed on a draft text and the mandate for the negotiations with the European Parliament, and the final report of the Parliament was adopted on the 23rd of January 2019, so very recently. And I think it was, the document is actually dated from the 29th of January 2018. And then we had a debate, the first plenary, first reading, on the 29th of January 2019. So that is the chronology. So now I come to the key issues of this report by the URI Commission and the text that they agreed upon. So let me have a look at what they said about stockpiling. Whereas the Council version didn't really, and the Commission version as well, didn't really go into the stockpiling details, the URI agreement of the Parliament clearly includes the possibility to produce generic and biosimilars during the SPC protection period, the patent term extension period basically, for export purposes. It includes the possibility to stockpile for 2 years to prepare for launch in the EU on day one after the SPC expires. And it also says that such stockpiling should be allowed during the final 2 years of validity of the respective SPC. So this is really some really radical changes. And you can already imagine that you think, okay, how does that comply with 28, 29, 30 of the TRIPS agreement? 28 and 30 of the TRIPS agreement. And when it comes to the application, another issue, the Parliament agreement, the URI agreement, plans to implement the SPC manufacturing waiver from January 2021. The original proposal by the Commission was at a much later date, the 1st of January 2023. And there will be a two-pronged transitional regime for the applicability of the manufacturing waiver. So it applies to all SPCs for which the underlying basic patent expires on or after 1st of January 2021, so much earlier than the originally proposed 1st of January 2028. And it will additionally apply to all pending SPC applications on or after the entry into force of the regulation introducing the manufacturing waiver. And this applies even if the underlying basic patent expires before 1st of January 2021. So there are some kind of retroactive effects built in to the legislation. Then let's have a look, what about the notices and safeguards? Also there, the current report, the current agreement, has become much more detailed and thereby has kind of, to reach a compromise, has met some of the requirements of the industry. So there have been introduced additional safeguards to ensure the transparency and avoid diversion into EU markets. such as a standard form, which is contained in a new access to the document, which must be used for the notification to each competent national IP authority, but not only. Also, it has to address and has to notify the SPC holder. And that is the big change to what we saw in the Commission proposal, and an important change to the industry. Also, to benefit from the manufacturing waiver, the manufacturer must notify not only the National Patent Office that granted the SPC, but must also directly inform the SPC holder in writing. So this rectifies one of the most apparent shortcomings, of course, and this must be done no later than 2 months before the start date of the manufacturing. Interesting, the protection of commercially confidential information of generics and biosimilar producers invoking this waiver is also further strengthened. For example, producers will no longer be required to indicate the precise addressees of the premises where the making is to take place, but must indicate the corresponding EU member states. Also, the National Patent Office notified by the producer shall only publish the corresponding SPC number, while all further information provided by the producer shall neither be published nor made available for inspection by the public. So this is again an important rule for the generic industry, because of course they, for their strategy to launch first in the market, they want to protect that information. The maker also must fully inform persons in their supply chain of the above conditions, and that the import or re-import of the product into the EU market would infringe the SPC. So this is also new, and that is of course a good thing for the brand name producers. Also, this report and this agreement includes a signature which clearly signifies that the outer packaging of any product manufactured under the waiver must be labeled with this specific logo. Okay. When it comes to the complete TRIPS agreement, there are of course still a lot of questions open. And the European Council introduced an amendment to these rules, the recital 11, that attempts to justify compliance with Article 27, 28, and 30 of the TRIPS agreement. So Article 11 seems to imply that some rights in Article 28 of TRIPS, such as preventing others from making, using, offering for sale, selling, or importing the products for these purposes, are at the core of patent protection, whereas other rights would be at the periphery of the array of patents. And we have seen this discussion before in the Canada case, right? So the question is then, would stockpiling be covered by the Article 30 exception? And in the Canada case, the WTO's dispute solution body said that stockpiling would not be covered. So it goes kind of against what we see in the recital 11. So this is really a kind of a question if the European Union would not risk to meet complaints about infringement of the TRIPS agreement here. And of course, the industry is not very happy about the current, although many things have kind of improved for the industry, but they would still oppose the inclusion of the stockpiling provisions. They would oppose the retroactive elements of the current rules, and of course insist on more detailed information about the producer and the export and the supply chain that the generic industry might want to keep secret. So there's still a lot of tension built in to the new laws, and I think we will see a lot of discussions going on in this area. But I will come back to that because the law will be developing, I think, because there will be reports after every 3 years, and I come back to that. So the law might be refined along the way. The question is then, should the US follow suit, right? Is there an idea that the US could think about similar exceptions? Again, the patent term restoration and the patent term extension in the US also provides an extension of up to 5 years. And because the US has tried, I know that from my sources in Brussels, they've tried to kind of oppose this development in Brussels. So if the lobbying fails, and it looks like it will, the question if the US might consider similar exceptions due to the concern that the EU proposal encourages some US producers of biosimilars and generics to shift capacity to the European Union. The problem is that current US law doesn't allow this. No manufacturer of patented products without the permission of the patent owner, regardless of intended destinations. And I think in 1984, this paragraph 271 was introduced, section F, into the US code, that even clarified that no domestic manufacturer of even the unassembled compounds of patented products, if intended for export in combination by overseas buyers, should be that the export should not be allowed of such components. And I think this rule was even confirmed by the US Supreme Court last year in the Western Gecko Geophysical Corporation case, which said that the foreign lost profits from sale of such exported components would be recoverable by patent holders. So as the law looks right now in the US, which does not allow this domestic manufacture for export, and which does not allow, and which would very clearly by the US Supreme Court decision here, give the patent holders right to recover the costs, I think this kind of signifies that it is very unlikely that the US would follow the same approach. It would at least be very difficult to do that in the US. So in conclusion, I think that the waivers could indeed have an important public health ramification in low and high income markets, but the benefits are not certain to materialize, I think, because export markets might be too small for some new drugs. There are lots of legal and logistical hurdles that might be too high. Of course, if attractive export destinations exist, the industry would, of course, maybe change strategy and would try to patent their products in those markets. Those strategies might be limited in cases where the products already have been marketed in those markets because of the novelty and non-obvious requirement in patent law. But in other situations, of course, the industry could start to patent in countries where they didn't patent before. But to make this SPC waiver a success and to really reap the benefits, I think it will be really important to provide as much detailed legal certainty for stakeholders as possible. And it is really, I think, questionable if the current version strikes the right balance. So it's very important to see how the committees, the Council, the Commission, the Parliament, how these negotiations will develop now. I think that the SPC waiver will become a reality. This is clear. But interesting is in the current version that there is a proposed Article 21A, which requires the Commission to carry out a re-evaluation not only of the manufacturing waiver, but also of the SPC system with regard to the waiver. And this has to be done every 3 years. And the regional proposal was every 5 years. So it is an unusual extent, I think, of presumed legislative drafting error in the final report. So it seems like they're not really convinced about the feasibility, and more data is needed. And of course, this kind of review process could, of course, help us to facilitate the resolution, the design of future issues with the manufacturing waiver by further curtailing the rights of SPC holders. And it is, I think, very important to monitor these developments and to draw your own kind of conclusions, and especially the US, I think we get a lot of interesting data by watching what the Europeans are doing, and if that really helps or where the issues are. So the European Union development that we see right now and the review of this law once it becomes effective could be really an interesting test case for other countries, such as, and also for researchers who study these issues, right? Because we will get a lot of data, I presume. But it could also be a test case for other non-EU countries, such as, unfortunately, the UK, hopefully not, but you know, it looks like it. But they, of course, have other issues right now. But let's hope that this law at least will succeed. Thank you very much.
So I have lots of questions, but I have two in particular. First is it the case that the drugs that we're thinking about here are drugs where there kind of aren't generics available at other places? Like, I'm wondering if the paradigm case is like, oh man, we really wish we could have generic whatever in Nigeria, and there's just no source for it because nobody makes it for them, and so we desperately need some manufacturer, and the EU folks are the only ones that are going to do it? Or is it like they're getting it from India and EU manufacturers want in on that and
Yes.
like to compete in that? Because if it's the second one, it strikes me I care a lot less than if it's the first one. Or sorry, if it's the second one, I'm much less worried. And the second question is, you close by saying, is this a cure that's worse than the disease?
Yeah, the title was, yeah.
And I'm just wondering, like, I've heard the story, but I'm not convinced. Like, it sounds like even if this goes into place, the answer is, at the end of the patent term, there's competition in the market where the patent was, as opposed to at the end of the patent term, there's like a slow ramp up until we can actually make the drugs in the EU, and then there'll eventually be full competition, which doesn't sound, again, like something I'm super worried about. So I'm wondering if you can help me out on those two things.
I'm not sure if I can help you out, but I think regarding your first comment or assumption, I think that's the second situation, right? That they want to supply this to Nigeria. But of course, there are more reasons for this law. It's partially that they want to have a competitive generic market in Europe and export these drugs, safe drugs, which are not counterfeited, to countries like Nigeria. But of course also, I mean, creating a kind of a generic or biosimilars innovation in Europe, right? So I think that's totally the case. And the second questions you had, I'm
just not convinced that there's like a big ill. I'm convinced that innovator pharmaceutical companies would really enjoy having more money.
Yeah.
That actually is not hard to convince me of.
No,
so I'm convinced that like what they would like is no stockpiling, so that on day one, you have to ramp up your manufacturing capacity, and like we're going to impose a lot of procedural barriers, and we would like to continue the absence of competition as long as we possibly can. But I'm not sure how much of this is like trying to stretch the patent bargain beyond what it already is versus, oh no, we're really cutting into what you actually bargained for here.
No, well, I agree with you, and I think the stockpiling will definitely be kept. And I think the biggest difference is that you would allow that in the European Union, right? So, but otherwise, I'm sorry if I don't get fully your point. We can chat about later. Yeah. Yes.
So is there a concern that implementing the SPC is being forwarded by lower income EU countries with an intent that leakage is going to happen domestically? So let me give you a case. Right? So one of the things that we actually just learned from Ariel just now, right, was that the higher income you are in the EU, the more likely you are to see biosimilar entry. And I'm supposing the reverse is true, that the lower income you are, the less likely you are to see biosimilar entry.
Yeah.
So if you are a low income EU country, especially one with high unemployment, what a better way to solve two problems at the same time than housing a manufacturing facility with this SPC waiver, knowing that some of the biosimilar that's intended for export is actually going to be delivered within your own country. Yeah. It's like, every Greek hospital is going to start making all of this stuff, right? I mean, is this one of the concerns that's being voiced?
Yes, absolutely. I mean, we saw that also in earlier parallel trade cases, but this is certainly what will happen, right? But this is why you have now produced all these safeguards with the logo, right?
Yeah.
But
it just seems like the legal advantages to Europe itself are minimal compared to the illegal advantages to Europe with the SPC waiver. I mean, I don't know. I mean, maybe someone else is less of a skeptic, but or a cynic. I mean.
Yeah. I think you have some very good points there, Jake, and I think I tend to agree. That is most likely going to happen.
Okay.
Yeah.
So this is just sort of an observation. So we collected all this data on and because one currently still does have to have a precise address of the entity responsible
Yes.
for the manufacture of the active ingredient and the
Right.
batch release of the product. I just pulled up the table we have of all the addresses for all the European biosimilar manufacturers.
Mm-hmm.
The observation that I have, which is just a very European fact, is
Mhm.
that it seems to me that the costs and benefits of these policies will unambiguously be unevenly distributed across European countries.
Yes.
And I was just wondering what you make of, so if you look at where the biosimilar manufacturing programs are, I hinted at this in my talk, we actually don't, there are more biosimilars than there are biosimilar manufacturing programs. It seems to be the case that there are a handful of basically biosimilar facilities that specialize in manufacturing scale up in places like Austria, Germany, Slovenia to some extent, and that's most of it.
Yeah.
And so it seems like, and I don't know if that's, it seems like one way or the other. So Austria is not a country known for its, robust innovator pharmaceutical industry, but it manufactures a heck of a lot of biosimilars and generics, and so it seems like the policy impact of all of this, if you're the Austrian generic manufacturing organization, I'm sure there is one.
Yeah.
Seems awfully different than if you're Portugal and you don't really have a generics or biosimilars manufacturing industry, and so you kind of you stand to experience the costs or benefits from the perspective of a healthcare system or a consumer, but the sort of the incidence of
Right.
policies, it's just an observation. It seems like it's because the generic and biosimilars manufacturing is so geographically concentrated,
Yeah.
it seems like there are a certain subset of countries that are going to just care a heck of a lot more.
Yeah. I think I tend to agree. Very good comments as well. That this probably is the case. And again, I think the biggest advantage of this is, of course, that you would have a huge stockpile on day one when the SPC expires under this new rule. I mean, that might be one of the biggest advantages.
If you're in the business of, warehousing drugs in Austria, that could be that could be a good thing.
Yes, exactly. Right. Yes. Well, I think, but it will be really important to see. I think this is going to happen. I think this will be, enacted. That's for sure. And then I think what's really interesting is to see this Article 21 reports that will be the reevaluation that will be conducted every third year. So this will, of course, I think, be very exciting to follow this, how this plays out. Yeah.
So I'm just curious if we have any data about the stockpiling point. I don't know how quick or slow ramp up of drug manufacturing is. It's possible that for biologics and biosimilars it's difficult.
Yes, that's difference too. Small molecule, obviously.
But I know that there's the Bolar exception, and in terms of winning approval, so you can definitely tool up your manufacturing line. You can get everything ready to go. Does it really take an appreciable, meaningful amount of time to kind of enter into supply, especially compared to the other hurdles that Ariel talks about it actually getting market penetration and getting buyer organizations?
Again,
is this a meaningful
I don't have the data on this, but this also relates to your talk, because when you have these settlements, a lot of these settlements will include collaboration between the brand name manufacturer producer and the biosimilar producer, right? So they will share knowledge probably, but often combined with a little delay of entry into the market. So I don't have data, but all these factors would need to be considered if it really helps, right?
I mean, I suppose we can argue that if stockpiling didn't have a meaningful delay, then companies wouldn't be so argumentative about it. But
true. That is, yeah. They seem to be really scared about the stockpiling rules. That's definitely the fact.
The way the current proposed law is, can any biosimilar manufacturers start stockpiling at the appropriate time, as long as they make the appropriate disclosures, or is there kind of is there a procedure to be an exclusive biosimilar stockpiler within those last 2 months, or?
No, I mean, I guess those who have the competences would do that during the last 2 years of the SPC, right, when they can start to stockpile.
So any number of manufacturers manufacturers can apply it, can make those disclosures?
Yes, that's how I understood it. Any who can meet the quality requirements, right? Yeah, exactly. No, but there are many, many open questions, and I think I share your skepticism. I mean, these are very good comments, I think. So, yeah, I mean, I didn't actually conduct deep research in this area. I was mostly like following what's happening, and I think the research basically starts now that we see like the contours of the law developing, right? Maybe we should have been a little bit more involved in the process when the rules were shaping up. But yeah, so this is going to be very exciting, I think, to see what's going on. Yeah.
I know that Dan Burke did a lot of studies
Yeah.
on like cross-border IP and gray market goods. It's a shame that he missed this section. I think he would have.
Yeah.
a lot to say about it.
I'm sure you would have. Yes. Okay.
Everyone join me in thanking Timo.
Thank you. Thank you.